Dear students of LLM second semester, feel privileged to welcome you all in the third video of my lecture series. Friends, in last two videos, we have already discussed in detail the different segments of delegated legislation in India. In today's lecture, I will be covering the second part of Unit 3rd, which talks about the control over delegated legislation, especially control by way of judicial control. Friends, I can say without any doubt that one of the significant and important development of the present century is the growth of legislative powers of the executive, which is popularly known as delegated legislation. Therefore, the study of delegated legislation occupies very important place in the study of administrative law in India. We all know that delegated legislation is mostly bureaucratic legislation. So, the question of control over delegated legislation assumes importance because if the executive is not to be allowed to act arbitrarily, friends, there are numerous critical reasons why it is necessary to have control over delegated legislation. So we can say that legislature having delegated their powers have to bear the responsibility to ensure that the delegatee shall not overstep the legitimate domain, but due to one or the other reasons, parliamentary control over delegated legislation becomes ineffective. As a result, some other control mechanism also came into existence. Finally, today we are having three different types of control over delegated legislation in India, which are first, parliamentary oblique legislative control, second, judicial control, and lastly, the procedural control. Dear students, as per your syllabus, the first control is prescribed as judicial control. So, I will be discussing first the judicial control over delegated legislation in detail in today's lecture. Rest two controls we will be discussing in the next coming video. So let us start discussing the judicial control over delegated legislation. But before that, I would like to raise a question before you, that what do you all means by the word judicial control over delegated legislation? It simply means the general power of court to see that the power delegated is within the ambit of the Constitution of India or not, as per Article 13, Subclause 3, Subclause A, which defines law and states that states should not make any law which abuses the rights given in Part 3rd of the Constitution. If any law is found to be against the ambit of the Constitution, then court declares it as ultravirus and invalidates the said law. The grounds of invalidating may be as follows. First, enabling act is ultravirus the Constitution. Second, the administrative legislation is ultravirus the Constitution. And the most important one, the administrative legislation is ultravirus the enabling act. Let's discuss the grounds of invalidating in detail. And in the list of explaining the grounds of invalidating in detail, the first one is the enabling act is ultravirus the Constitution. According to this ground, If the enabling act is ultravirus the constitution, the rules and regulations framed thereunder would also be void. The enabling act may violate either the implied or express limits of the constitution. In the light of this observation, we can say that legislature cannot delegate its essential power to any other agency, and if it so delegates, the enabling act will be ultravirus the constitution. This form of invalidating is also known as excessive delegation, and this is generally decided by the court on the basis of examining the following facts. The first fact, which is examined, we can incorporate in the form of a scheme of the statute including preamble. The second fact which is to be examined is the facts, circumstances, and background under which the statute was enacted. Third point we can incorporate in the form of history of legislation. Fourth, liberal construction be given. And finally, complexity of the problem which the state has to face. On this point, we can refer an important case in the form of Mohini Jain versus State of Karnataka. The another ground on which the rules and regulations may be invalidated in this head is the enabling act violates the express limits prescribed by the constitution. For example, if enabling act violates the article 20 of the Indian constitution, then it is going to be declared ultravirus. One more case where the constitutionality of enabling act may be challenged is where the enabling act is violative of part 3rd of the constitution. Here we can quote a case of Chintaman Rao versus State of MP. In this case, CP Regulation of Manufacturers of Bidis Act 1948 was challenged. This act has given wide discretionary power to the Deputy Commissioner to fix agricultural season and prohibits the manufacturing of bidis in the notified areas in that season. The Deputy Commissioner imposed a total ban on the manufacture of bidis. The Supreme Court held that this act and rules framed thereunder are ultravirus because it violates the fundamental right given under Article 19(1)(g) of the Constitution, which guarantees freedom of trade and profession. The second ground of invalidating is the administrative legislation ultravirus the Constitution. Dear students, sometimes it may happen that the enabling act may not be against the ambit of the Constitution, but the rules and regulations framed thereunder may violate the provisions of the Constitution. If it's so, then even then the act is going to be declared ultravirus. It was held in the case of Narendra Kumar versus Union of India that even if the enabling act is intravirus, the constitutionality of delegated legislation can still be considered because the law cannot be presumed to authorize anything unconstitutional. The other ground of challenging the rule making by administrative agency may be on the ground that it is discriminatory. This was well explained in the case of Love Chandra versus State of Bihar. In this case, the management of Jain temples were given rule making powers, and by exercising the same power, the management restricted the voting rights of person who had attained the age of 21 and had made a donation of not less than 500 to the temple and were also living within the estate from last 10 years. The Patna High Court held that the rule providing for the management of Jain temples to be discriminatory and hence violative of Article 14 of the Constitution, and in this way administrative legislation ultravirus the Constitution. The third and the most important ground of invalidating the Act is the administrative legislation is ultravirus the enabling act. Dear students, the constitutionality of administrative rule making may be challenged on the ground that it is ultravirus the very enabling act, but the worth of this challenge depends upon the following counts. The first count, that it is in excess of the power conferred by the enabling act. Dear students, the question whether the delegated legislation is in excess of the power conferred on the delegate has to be determined with reference to the specific provisions contained in the statute and also the object and purpose of the act as can be gathered from the various provisions of the enactment. Here we can again refer the case of Mohini Jain versus State of Karnataka. The next ground is that it is in conflict with enabling act. The administrative rule making can also be declared ultravirus and invalid if it is in direct conflict with the provisions of the enabling act. In other words, we can say that administrative rule making can be justified only if it is in consonance with the different or all the provisions of the enabling act. The next point or count may be that it is unreasonable, arbitrary, and discriminatory. The unreasonableness of administrative rule making can be challenged on the ground that it violates Article 14 of the Constitution. The Supreme Court of India, in the case of Air India versus Nargis Mirza, questioned the service regulation framed by the Air India, which had provided for the termination of service of an air hostess on the first pregnancy. The court held that its regulations are unreasonable and arbitrary and interferes with the ordinary course of human nature and hence violative of Article 14 of the Constitution, which guarantees equality before law and equal protection of law. The next point we can incorporate is that it is malified. In India, subordinate legislation can be challenged on the ground of malified or bad intention. The next point we can refer is that it conflicts with terms of other statutes. Dear students, it may be possible that in some cases the delegated legislation conflicts with the provisions of some other statute. In India, on the basis of different decisions given by the Supreme Court of India, we can say that now it is well settled that a rule is not only required to be made in conformity with provisions of the Enabling Act, at the same time it must be in conformity with the provisions of the other existing statute. The next point of discussion is the waiver of the rule. The relaxation in any rule by the administrative authority is not permissible because it may lead to discrimination, arbitrariness, and favoritism, which is opposed to the rule of law and constitutional values. The last point we can refer here is the vagueness. The administrative rule making power can also be challenged on the ground that a rule made by the administrative authority does not lay down the date from which it will came into effect. Then it can be challenged on the ground of vagueness. Friends, finally, we can conclude the topic judicial control over delegated legislation in following words. We can conclude the topic judicial control over delegated legislation in the sense the judicial control over delegated legislation occupies an important place in the field of control mechanisms. The judicial control means assessment by the court of the legal validity of a piece of delegated legislation, which the court may do either with reference to constitution by applying the doctrine of ultravirus or with reference to other recognized principles of law. That's all about the judicial control over delegated legislation. Thank you very much.